cheaper. There are situations where it can be just as expensive as a probate, and in some cases perhaps even more expensive.
Okay. We talked about this before in another context, but the situation now after a death, quite often, I've had this experience recently, again related to my father's estate. Actually, my parents had a trust, that they were required to pay back certain items. For example, the Social Security that was paid for his month of death, his pension payment that he received for the month of death. So what about concerns related to cash requirements and how much maybe that you should keep on hand for these types of contingencies?
The question goes to kind of planning for death and having some sort of liquid assets available to meet some unexpected expenses. Certainly, you're going to have funeral expenses.
Yes.
Certainly, you're going to have some last illness bills that are going to come trickling in shortly after death. And as you correctly pointed out, Social Security is going to require that the last Social Security payment you may have received, unless you died on the last day of the month, needs to be refunded back to the Social Security Administration. And many pension companies will ask that the last month's pension be reimbursed. In terms of access to cash, I'm not sure that there needs to be substantial cash reserves, because most creditors are going to indulge you a month or 2 months' time to be reimbursed. Oftentimes, if there's no surviving spouse and the trust transitions to a successor trustee, the successor trustee may very well charge the funeral expenses on his or her personal credit card, and the minute they have control and access, they'll get reimbursed. And the same thing goes with any other urgent bills that come in. More often than not, I just have my trustee collect them, and then once we transition control to the successor, we get them reimbursed as soon as we have liquid funds to do so.
Okay. All right. What is the significance of a death certificate? And also the significance, I guess we talk about these together, of a trustee certificate.
A certification by trustee is a statutory form that basically is a document that we would prepare for a successor trustee, indicating to the world that they are in fact the trustee, that the tax identification number for the trust, kind of like the Social Security number for your decedent, is a particular number, and that the trust is either revocable or irrevocable, and a number of other things that the statute requires. That form, that trustee certification, is a form that, when combined with the death certificate, will oftentimes open the doors to the trustee to be able to gain access and control of the deceased settlor's bank accounts, brokerage accounts. They'll be able to file claims with any sort of pension, assets, retirement benefits, life insurance, things of that nature. Without them, it's oftentimes going to be very difficult in order to obtain control of the deceased settlor's assets.
Right. So these are sort of like the minimum, or you need to have these documents really to act. And
right. These are some of the first documents we're going to create. I mean, we're not going to create the death certificate. We're going to obtain the death certificate from the coroner's office, but we're going to have the certification of trustee ready for the client to sign so that they can obtain the control of the trust.
Now, if you're nominated as a trustee, do you have to accept, and what should you think about before you accept?
This is the very first decision that you have to make. In a trust instrument, it's not uncommon that the person who creates the trust is is frequently the initial trustee. But upon his or her death, there's a successor trustee nominated in the instrument. If you're that person, if you're the nominated successor trustee, the first question that I'm going to go over with you is, should I take on this role as trustee? And there are pluses and minuses. Yeah, this is a job. and this is a job that has a lot of duties and responsibilities associated with the job. And if you don't carry it out properly, you're going to be held liable to the beneficiaries of the trust. So before taking on the job, the questions that I ask my client are, number one, do you want this job? Number two, assuming you want it, do you have the time to properly do and perform the obligations as trustee? And then three, are you willing to be a target if there's a dysfunctional family or there's a disgruntled beneficiary or anything like that that may take up even more of your time? Even with very good legal representation, this is not a task for people that are very, very busy and don't have the time to carry out the obligations that the settlor wanted you to carry out.
Right.
So think about it carefully before accepting.
Right. So it is something to take seriously. On the other hand, some people are afraid, well, I've never been a trustee before. I don't know that I totally understand this, whether they should take it on for that reason. And I think we want to give them some reassurance that, there's help
Sure.
available, that attorneys, CPAs are there to hold their hand along the way.
Professionals provide a significant service to particularly inexperienced trustees, someone who's never done this job, don't know even where to start, don't even know where the resources are to read about it. Most attorneys who specialize in this field are going to be able to guide their clients on a step-by-step basis, have frequent meetings with them, provide them with action lists so that they're adequately protected.
Right. Okay. What sort of notice requirements apply for trustees?
If you are a successor trustee and you have taken over control of an irrevocable trust, or a trust has become irrevocable as a result of the death of the settlor, the trustee has to send out a notice to all of the deceased settlor's legal heirs and to all of the deceased settlor's beneficiaries under the trust. And this notice is a fairly straightforward two-page notice, but it basically says, look, I'm the trustee, and here's my address, and here's how you can contact me. And that the trust you have, if you disagree as to whether or not this trust is valid, you have essentially 120 days from the date you receive this notice to formally challenge the validity of the trust. It basically creates a statute of limitations upon which heirs and beneficiaries can challenge the validity of the decedent's trust. That notice technically has to go out within 60 days of the trust becoming irrevocable. Oftentimes we don't meet that 60-day deadline because the clients don't come in until well after that. But that's one of the first actions that we will do, is send out that notice to all of the heirs and beneficiaries of the trust.
Right. And there's also an optional procedure related to creditors, is that right?
That's right. California law has developed an optional procedure where you can actually go into court and open up a court file for a trust, somewhat akin to a probate administration. It's not a formal supervised probate, but you can publish notice to creditors, and you can give that published notice to all of the creditors of the deceased settlor who are known or reasonably ascertainable. If you do that, if you use the optional procedure, you shorten the creditor claim period from what otherwise would be 1 year after date of death to 4 months from the date this notice to creditors is published.